Thank you again for joining us for the DCSBDC webinar series. We do these series monthly to help businesses navigate through COVID-19. My name is Danielle Ricks. I am the owner of Danielle Ricks Productions, which is a small media production company. But I'm also a counselor with the DC Small Business Center Development. And I'm here with one of our other subject matter experts to talk you through a great topic today. I'm admitting people as I'm talking to you guys. We are at capacity, so there are 5 people waiting in the waiting room, so let me admit all of them. As I admit you guys into the webinar, please make sure that you are on mute. The other bit of housekeeping I will ask you to do is to please put your name of yourself or your business, however you were registered with the DCSBDC. I want to make sure that you get credit for showing up. I also want to make sure that when this is over, you get a copy of the presentation. And the only way to do that is for me to recognize who registered. And sometimes people register under a different name and not the name that I can find you in the DCSBDC database. So if you have registered under a different name or you haven't registered with your company, put that in the chat feature for me and I'll make sure that you'll get a presentation after we're done, because Selma's about to drop some knowledge on you guys, right? There's gonna be a lot of information and you're gonna wanna have this afterwards. So the first things first, we'll introduce our guest. So happy to have her back with us again by popular demand. She's gonna go over the goals of the presentation. She's gonna talk about trademarks. What are they? Who needs them? She'll talk about Goodwill explained, which I can't wait to hear because I don't know what that's about. So thank you, Selma, for putting that in there. I have no clue what that's about, so thank you. And then she's gonna talk about the registration process as well. It's the millennial business lawyer, you guys. Let's give her a round. You can't hear her, I can't hear your claps, but I know you're doing it. Her last webinar with us was so popular that we have asked her to come back again, and here she is. I'm gonna turn it over to you now, Selma. You can go ahead and tell everybody, let me back up a little, tell everybody about your law firm, tell them about the services you offer, and then we'll dive right in.
Absolutely. So thank you again for having me. I'm so excited to do this because I love to educate. I think it's the most important thing to have as a business owner is being able to learn, what are the things that you don't know, and a lot of us don't have mentors, so I'm happy to do this. So thank you again for having me. So as Danielle stated, my name is Selma Bankaboom, the founder of the Bankaboom Law Firm, and I've branded myself as the millennial business lawyer, and I'm so excited to assist you guys and give you guys some knowledge on trademarks. My firm primarily focuses on intellectual property rights as well as corporate law. So we support small businesses from business formation all the way to the exit strategy, and then also protecting their IP rights, or is what I like to call their creative greatness. All right, so the goal, I guess let's start with a legal disclaimer so that everyone's on the same page. Obviously, this legal webinar doesn't create an attorney-client relationship with you or me or with my law firm. The information is really intended to be for educational purposes only, and you'll still need to hire an attorney to be able to protect your trademark rights. So, and I also want to say that I don't talk about everything you need to know about trademarks. This is just kind of some of the main things or the legal nuggets that I think every business owner should know. All right, so the goal of this presentation is really not to give you a DIY, process of how to do this yourself. You really want to be mindful of the fact that it does require a licensed professional to protect your trademarks, and making sure that you're mindful of that. So you really just want to understand what are the things you need to know as a business owner, and when is it time to hire an attorney, and you're well informed about at least trademarks and understanding how they work. Thank you. So then the topic that we're going to discuss today is obviously trademarks. We're going to discuss what exactly they are and whether or not you need to register them. A lot of times when people think of trademarks, they just think of the logos and the names, and that they kind of stop there. But today we're going to learn about what exactly do they mean, and what is it intended to protect, and what is it that you need to know. All right, so what is exactly a trademark, right? So really a trademark is an intellectual property right, which there are 4 intellectual property types. Trademarks is just one of them. And it's one of the intellectual property rights that is applicable to all businesses. So the other 3 types, some businesses may require them to protect their IP, other businesses may not. But trademarks is definitely something that every business owner needs to be mindful of, because that is really how you protect your competitive edge in the market. because it essentially protects your brand. And we'll talk about the goodwill of the value of that brand, and it's how your consumers identify you in commerce. And you as a business owner, you want to make sure that you're distinguished in commerce and that you are not considered a copycat of another person's business, and that you're securing the traffic to your websites through your name, and ensuring that you are, one of a kind, service provider or the products that are being sold. So the main thing that you care about as a business owner is that your goodwill is protected. And your goodwill is what's earned through your brand identity that you've developed with your consumers, which will avail you the right to prevent other people from adopting similar marks that are likely to cause confusion in the marketplace, which is what the government cares about. The government cares about, are we confusing reasonable consumers into purchasing knockoff products, or are they being duped into a service provider that's not who they bargained for? Next slide.
Yes.
Thank you. So goodwill is really important, right? And I think nowadays, given the current climate, a lot of companies have been paying a lot more close attention to their goodwill. I know that as millennial consumers, we care a lot about a company's standards and what they stand for. In fact, a lot of our decision making when we're purchasing products or engaged for services, we look to what does the company really stand for, and who is behind the company, and what does it really represent. So if you're struggling to figure out what your goodwill is, I want to give you some questions to kind of help you understand it. Oh, can we go back to the other slide? Sorry, yep. So I kind of want to describe a little bit more about the goodwill so that you have an understanding. Now, this is not an exhaustive list. This is just kind of something to get your mind and your creative juices flowing. So the goodwill can consist of the brand name and what it represents, obviously, your customer relations, your good employee relations. A lot of times people don't really think about that, but consumers definitely look at that. Your proprietary technology, if it's something that you do that's so unique and different, that distinguishes you from your competitors. The quality of your products. If you're, in the goods industry, obviously shipping standards. I know that I make some decisions in my purchasing based off of, how fast is the shipping. I think that's why Amazon is the mega corporation that they are today. It's the fact that we're able to get what we want, and we want it fast. And then lastly, values and how it shows how you show up in commerce for your consumers. And this became really important this year. And that's what I was referencing earlier when it came to what does the company stand for? Are they staying silent during a time where consumers are, everyone's talking or in the conversation, or are they just kind of, on the back end, just trying to coast through, right? I think millennial consumers now, we're very aware of which companies stand up for things and which companies just kind of stay out of the way. So some of the questions that you want to ask yourself to develop your brand identity. So next slide. Thank you, Danielle. Why should a consumer purchase from you versus your competitor? What makes you different, right? What is that, it factor that makes your company better or different or, than a competitor? What are your company's values, right? What is your why? And, how do you go about providing the services or selling the products, or what kind of products are you selling? How do you treat your employees? That's part of the conversation of understanding the goodwill and the value of that trademark. And how do you show up in commerce for your consumers? And one of the things that you want to be mindful of is, what is a consumer's impression or opinion of your company after they've had an experience with you? That's essentially how consumers make decisions, and that's what drives, reviews, and that's what drives people to purchase from you over others, right? So let's go over some examples of goodwill at play. Next slide. All right, so, there are people that primarily purchase products from Walmart, and then there are those that purchase products from Target, right? So you make a decision based off of that. So they're both doing the same exact thing, although Target might be a little bit pricier, but maybe Target offers different products that Walmart doesn't offer. What makes their, consumers' decision to shop with one over the other? Bargain shoppers love Walmart for their prices. So those are the things that you want to think about in terms of, a company's goodwill and what it stands for. Then another industry, talking about Nike versus Adidas. Nike, for a long time, they had great designs and great quality. Adidas just recently started using influencers and started using different designers so that they can kind of compete with Nike over the past, I want to say 5 to 10 years, right? And then also we have, you know, the Apple people and we have the Android people, right? You know, you're deciding whether or not you want to purchase something from Apple or whether or not you want an Android based off of the software, whatever your preference is, you know, figuring out the distinguishing factors and what matters to you, right? And then also we have, you know, as of this year, we've had some social issues where a lot of companies that may not necessarily have, you know, social issues as part of their services, they started speaking out. And the one brand that sticks out to me the most is Ben & Jerry's. So a lot of people celebrated them for standing up for social injustices. And then some people actually were upset. And, you know, these are some of the kind of the backlash of them speaking out, but it didn't prevent them from continuing on because they realized that they were essentially doing what was right and what was within their values and aligned with their mission for their company. And so, you know, they stood their ground and you know, did it regardless of how people thought. Then we have Aunt Jemima and Uncle Ben's, where essentially they came out after everyone else did and basically stated, well, you know, we feel that some of our logos are, you know, have some racial type of issues. They were stemming from racism. And so now we're going to rebrand because we want to stand for the mission. But with, you know, what they did wrong is that they were like a little too late. So at that point, it didn't really come off as genuine. So there was a lot of conversation about that and whether or not they were really trying to commit to the social mission, or they were just, you know, trying to hop on the bandwagon once they saw that it was safe to do so. And I also want to mention that with Nike, they took a huge stand, and they were kind of the pioneers in this social injustices issues when they signed Colin Kaepernick, and, you know, they took a huge risk. Everyone thought that their stock was going to, you know, go under. You know, they really felt like they were making a huge mistake, and come to find out they were actually having their most successful year because of that partnership with Colin Kaepernick. So that's some of the ways in which you can think about the goodwill of your company and what it stands for as far as its values and what it represents. So let's talk about registration of a trademark. So you're able to register a trademark at the federal level with the USPTO. You can also register a trademark at the state level with your Secretary of State. And each state has their own bodies of law that govern those trademark registrations and what they stand for. And then you can also have international registration. You typically would do that with the Madrid Protocol for the countries that have opted into the Madrid Agreement concerning the international registration of marks, and where you're able to, you know, have your trademark registered in each of those particular countries, depending on where you're selling your goods, right? Next slide. I do want to say, you know, that not all trademarks are registrable. You really have to understand what qualifies for trademark registration at the federal level. And the reason why I'm focusing on the USPTO's registration is because that's what's going to provide you the most protection nationally. So, you know, you're more than welcome to register your trademark at the state level, but now that a lot of us are engaged in interstate commerce, cross-border transactions from state to state, you really should avail yourself of the USPTO's protection so that no one else is able to utilize the same name or something similar in another state. And that becomes really important for PR issues. So let's say, for example, a competing company that sounds like your company or looks like it committed fraud, and there's this huge, you know, scandal, and it's all over the news. You don't want your consumers to be confused with you because you're in a different state. You want to make sure that you have that national protection, right? So for a mark to be protected at the federal level, it must first be distinctive. And this is basically, it has to be so different and unique that it's able to identify a single source of that good or service that you provide, right? And then it has to be used in interstate commerce, obviously, across state lines. And now that we're all basically operating virtually, a lot of us in e-commerce or even as service providers, we all have websites that bring traffic from other states. So we, for the most part, will qualify for that interstate commerce requirement. Next slide. So not all trademarks, though, that are distinct and used in interstate commerce can be registered. So there's certain subject matter that the law states that should not be registered under any circumstances. First are those marks that cause a likelihood of confusion in commerce, and that's basically, you know, the policy behind that is they care about a consumer, wanting to make sure that the consumer is not being misled in commerce. Generic terms, which is basically terms that say exactly what it is that you do or sell. So let's say I have a phone company for cell phones. I can't call that cell phone and say that no one else is able to utilize cell phone, because obviously that's a generic term and it would be ridiculous if no one else could use that term, right? Deceptive matter, so anything that's misleading in commerce obviously is not eligible for registration. Functional matter, matter that falsely suggests a connection with a person or institution. Governmental insignia, names, portraits, and signatures identifying particular living individuals without their written consent. So you're able to still register them, you just want to make sure that you have written consent, and there's forms for that. So let's talk about the main, next slide, sorry.
Oh yeah, hold on, there we go.
So let's talk about the main issues that I see come across my desk is really primarily, logos or names or trademarks that cause a likelihood of confusion in commerce. So I utilize some examples here to give you some ideas on what are considered likelihood of confusion. So a lot of times people will come to me and say, well, it's not exactly the same. I spell it differently. It's different logo because I changed a little bit of the features on it. I don't understand why I still can't file it because it's not the exact same. The legal standard for likelihood of confusion falls on 13 factors that we have to weigh to figure out whether or not a reasonable consumer would likely be confused. That reasonable consumer standard is really low. So don't think of it as an educated consumer, and don't think of it as a consumer who's going to take the time to look it up. It's literally the consumer that glances at it and is able to be confused from there. So a perfect example of that is we have Adidas, and here they put Abibas, right? They tried to get cute with that. And obviously, if you glance at it, looking at it fairly quickly, you're going to assume that that's Adidas, unless someone points it out to you that those are B's and not D's, right? Here we have something a little bit different, but McDowell's, same type of M feature, it's yellow. Although that they don't have the red, they featured it with the green. It still sounds the same and it looks the same, so it can come off as looking like a knockoff, right? Here, it's not as clear, the grab and go burger is competing against In-N-Out. However, think of it as if you're driving in the street, you might just look at the yellow and red and just assume it's the same, and they all have some sort of circular motion or some sort of feature that could be confused, right? Here we have Nike. They spelled it wrong, right? They had the Nike check logo, and then their slogan was "Must I make do it," right? As opposed to just "do it," which is the Nike slogan and trademark that they have registered. So if you're looking at it from far away, it can be considered, confusing to a reasonable consumer. And then all the other ones are pretty much self-explanatory. You can kind of see the differences there. All right, so let's talk about how to identify trademarks, right? So what are the different types of trademarks and how do we identify them? Obviously, everyone knows about names and symbols such as like logos, right? Slogans can also qualify for their own trademark. Colors, for example, we have the Tiffany box here. Tiffany's has over 100 trademarks registered. So one of their trademarks is the Tiffany blue, along with their packaging as well. And then we also have sounds, right? So if there's a certain sound that is associated with a company, that's eligible for registration as well. Package or store design, such as Apple's store design, they registered that as a trademark. That's why all of the Apple stores look the same, and they definitely do not want any other competitors competing with them. Because if you think about it, when you're walking through the mall, I don't have to look up to see that it's the Apple symbol or logo to know that it's an Apple store. They pretty much all look the same. And then here we have the Maker's Mark liquor bottle. So what they decided to register is the shape of the bottle and the wax, right? So that no other competing brand could have the same type of wax coming from that same shaped bottle. And then the other thing I wanted to mention to you guys are domain names. As of this year, thank you to bookings.com. That case went all the way up to the Supreme Court. And now the Supreme Court has ruled that we're able to register domain names, which is awesome sauce. It gives you a lot more leverage for cyber piracy type of issues, right? I think next slide. So once you're able to identify your trademarks in commerce, Danielle, is that you with the circles?
I don't know what that is. I don't know why that circle is there. And I don't know how to get rid of it. Huh.
Yeah. Okay.
Oh, it's gone. There we go.
Okay. All right. So once you identify your trademarks, you need to identify your trade channels because that's the classes that you're going to register the trademark in. So one of the biggest issues that I have seen with people that have done their own trademarks themselves or even utilize one of those cheap services online, they're not clearly identifying the trade channel and therefore your trademark may be registered, but it's not registered in your relevant market, right? So that can be a huge issue for you because you're missing out on an opportunity there and you basically, you know, can do nothing with that trademark and it can be considered misleading, right? So there's 45 international classes or trade channels that the law has identified in which you can register a trademark, right? So for example, here, one of the ways that it's easy to explain through an example, we have the Dove soap company and then we have the Dove chocolate. Now, if I were to just hear Dove, obviously I'm going to assume it's the same company and you're talking about the same thing. However, because the trade channels are so different, there is no way that a reasonable consumer can look at that Dove soap and eat it as chocolate, right? In alternative, there's no way that a reasonable consumer will look at the Dove chocolate and assume that it's soap and that you're supposed to utilize it, you know, to take a shower in. So obviously the law recognizes such distinction and allows people to coexist in commerce so long as they are in separate trade channels. So identifying the trade channel is, you know, a legal analysis that you want to have an attorney be able to identify for you. The way in which you describe your services and your goods is what really gives you that legal leverage when there are disputes. So you want to make sure that you hire an attorney that's able to identify those particular descriptions to be able to avail you of the best protection that you're able to. The next thing that you want to make sure that you let your attorney know are your future plans. For example, let's say I had a client once who was selling jewelry. And then at one point she planned to expand into handbags. And so it was important for me to know that so that I can make sure that I protect the brand in her handbag industry because they're in two separate industries. And therefore I wanted to make sure that I filed a separate application on the intent to use to preserve her priority date and to preserve the right for her to utilize that trademark within that trade channel. Because if a competing brand decided to file a trademark in a separate trade channel that she's planning on growing into, you know, jewelry and handbags are two separate things. So the USPTO examiner doesn't know about your jewelry business. So all they're going to see is that there's no competing brands within this trade channel. So therefore they're going to move forward with it. And it becomes very expensive trying to fight it at that particular time. I will say that you always have common law rights to your trademarks once you start using them. So your priority does kick off at the date of first use. It's not really the person to first register, and the person to first use a trademark has the priority rights and they're considered the rightful owner. But a trademark registration gives you the presumption, the legal presumption that you are the rightful owner. So, and it's a really heavy burden to try and overcome once a trademark is registered, right? Next slide. So now we want to talk about whether or not you should register your trademark. So once you identify your trademark, you understand your trade channels, you know, and you've done a clearance search through your attorney where they basically told you all the legal hurdles that you might run into, or if you have the green light to move forward with it, does it really benefit your business to register your trademark, right? Well, it absolutely does. It actually tells you the ownership of the mark, right? And now it becomes an intangible asset that has value to it, in which you're able to actually license the right for people to use it, right? So especially if you're thinking about expanding into franchising and things of that sort, or partnerships with others for them to be able to use your name, and the goodwill that you've built up is what adds that value to that trademark, right? And you absolutely have the exclusive right to use the mark nationwide in connection with the goods or services covered by that registration. It's really important that you understand that you only have that exclusive right based on the trade channels that are covered by the registration, right? And obviously it puts more validity on the mark. You have the right to use the R in a circle symbol. That symbol is only eligible for use for those who have actually registered a trademark and have received the trademark certificate in the mail. If you use it prior to that, it's considered false advertising and the FTC can come after you. So make sure you're not using that. You're using the TM symbol, which is the common law right to that trademark. And like I stated, you're able to license the mark for others to use it and charge them a fee for that. So you're able to make residual income. You can sell your marks, which can have a lot of value on it, depending on the goodwill that you've cultivated. And sometimes it can just be the name. Some trademarks are, if you did not decide to use it, or are planning to sell your business and you have a really unique name that's a cool identifying feature of your brand, it could potentially be considered to have high value. So that's something that you want to think about. And then the other thing that a lot of people don't consider is that you're able to use it as collateral to secure financing. So if you have the mark registered, you're able to essentially offer it as part of your collateral whenever you're dealing with banks or any type of lender. All right, so what, as a business owner, what is it that you need to know about trademarks? So the main thing is you want to adopt a strong trademark and make sure that it's original and doesn't cause a likelihood of confusion and that it's not generic. I know that it's very difficult to build a brand and to get that exposure and recognition. So a lot of people are tempted to utilize words or phrases that describe what it is that they do. And that's pretty much a weaker trademark than you would as if you had something unique and arbitrary, such as, and what I mean by that is a word that doesn't mean anything, right? It doesn't have any meaning other than what it represents, which is identifying your company, right, as a source of origin for that service or product. Now, those types of trademarks, although they are a lot more valuable and a lot stronger once the goodwill is cultivated, they do require a lot more marketing because people don't really know about your brand. But here's somewhat of a secret that I can give you guys, or a tip that you're able to utilize. So you're still able to use the phrase of describing what it is you do. So let's say, for example, you have a educational service, right? So you could potentially say, use an arbitrary name, Uber, right, is an example of that. Educational services. So you would register the Uber, but then we would disclaim educational services within the trademark application so that you're able to use it together as a phrase, or you're able to just use Uber and drop off the remainder of the phrase once you get enough brand recognition and people are just able to call it Uber, right? So that's somewhat of a tip for you guys to be able to still kind of get the benefit of both bargains there. Making sure that you identify your relevant market. A lot of times people don't really know what their trade channels are, and it requires me to dig a lot more to figure out what exactly do you do, especially in today's day and age where we're innovating and we're creating new avenues that didn't exist before. It's really important that you understand what exactly are you selling, who is your target audience, because that's really what we're looking for, is where is the reasonable consumer going to be hanging out when they're looking for your services. So think of it from that perspective, and then be able to identify all of the features of your business. Sometimes people don't include everything. You want to include every type of service that you currently provide, in addition to whatever services you're planning to provide within a few months or whatever it is. You just want to be very thorough in explaining exactly what your company sells or what your company does for a service, right? Priority use is really important to make sure that you have in place. So this, again, is what gives you the rightful ownership of who used it first. So in the event that another company comes at you later and says, hey, that's my mark, I was using it in Utah first and you copied me, right? So you want to make sure that you have the priority use, the date, exact date of how you used it, where you used it, take a screenshot of it, have some digital print of exactly how you used it and where. And then also the date that you used it in commerce, right? So that's really important to ensure that you have that priority, the exact priority date, because a lot of times it hinges on that. That is one of the most frequent ways in which people cancel trademark registrations, which once you have a trademark registered, it doesn't mean that you're free from any kind of legal liability. If someone else used it before you, or if you stop using it, or you're not using it correctly, there's a slew of different ways in which people can attack your trademark. So then the next thing you want to think about is claiming your trademarks. So as I stated before, you want to use the TM symbol on all of the trademarks that you intend on identifying as a trademark of your company. Even if you're not really sure, just go ahead and put that TM on it, because you will avail yourself of, the benefits of having intentional infringement in the event that someone else decides to compete with you in that perspective. And you can go after them for treble damages, which is a lot more, and it gives you a lot more legal leverage as opposed to you not using that, and then they didn't even know if that was your trademark or not. And then, as I stated, don't use the R in a circle because it's misleading, and if you don't have a registered trademark within your trade channel, it can be considered deceptive, and the FTC will definitely try to come after you. And then determine the value of your trademarks, right? So as I stated before, the value comes in your goodwill. Most people spend so much time trying to figure out the perfect logo and the perfect aesthetics. None of that matters if your goodwill is not really valuable, right? So if your shipping standards are awful, if your communication with your customers is awful, it doesn't matter how pretty your logo is or how nice or how unique it is. It doesn't mean anything. And the alternative, it doesn't matter how basic your logo or branding marketing materials are if you provide value that gives, that increases the goodwill of your company. A prime example of that is the Nike check logo actually cost Nike $35. So they didn't spend a lot of money on the actual logo. It's pretty simple. However, the value of getting a trademark logo such as Nike's is extensive right now. Obviously, no one is able to utilize that or affiliate themselves with Nike without paying a pretty hefty penny, right? So think of it from that perspective. Don't spend too much time trying to get the perfect aesthetics. You want to make sure that you're spending the time in understanding that it's a strong trademark eligible for registration, and that you're spending that time cultivating what your company will stand for and how the consumer is going to feel after an experience with your company. And then hire an attorney to file your trademarks. I can't stress that enough. And I know it may come off as biased because I am an attorney and this is what I do, but honestly, truly, we make a lot more money when people make mistakes. Trademark infringement suits are 6 figures and up. So, and a lot of times it's a losing battle. And a lot of times, if you work so hard to cultivate this brand, only to be, hit with an infringement suit, and then you have to rebrand, which I've had a couple clients that have, hit that unfortunate hindrance in their business. And if they would have just spent the money up front, they would have known not to bark up that tree and rebrand on the front end before they started marketing, before they spent all that money on all of their marketing materials and efforts. And then it looks bad in commerce. Consumers pay attention to that. And so if you have to rebrand, you're going to be considered a new company starting from scratch. And a lot of times the consumer might think, well, I wonder why. Did they get sued? Like, what happened? It doesn't make sense as to why they would just change their name like that. It must have been something awful might have happened and they didn't want to be associated with that name anymore, right? Some people get cute when they, change their name when they get bad reviews. That may or may not work in your best interest. So you definitely just want to have an attorney on your side to help you and assist you through the process. All right, so I went through the basics of it all pretty quickly so that I allow time for questions, because that's when people really, I know that it's a lot of information, but I really want to answer questions for you guys. So feel free to shoot them.
Yeah, please. I have a couple of questions in the chat, and I had a couple too myself I'd like to clarify. So Nike trademarked the symbol. Did they also trademark Just Do It? Because Just Do It is just as popular, right, as the symbol itself. So do you trademark logos and taglines?
Absolutely. You register each trademark. So a tagline is considered a trademark. A logo is considered a trademark. When you use them in combination, that's another trademark. So you have to file an application for each one. So one is not going to be a one size fit all.
Right.
That's why I gave the example of Tiffany's. They registered over 100 trademarks because they literally are protecting everything. So anything that identifies them as the source of origin of that product, they want to make sure that a competing brand cannot use the same type of branding, right? So that they're able to basically be a staple in the market, and a consumer can identify a Tiffany's box just by looking at it. You don't have to put the name on there.
So I have a client that I hope is on the phone because I'd like you to clear something up. I think that when small business owners go and register their business, that they think they're also trademarking and registering their name. So they have registered their business with the state, but that doesn't mean that somebody in Europe doesn't have their name. So the first thing, correct me if I'm wrong, is to find out is your name, can you legally use your name before you even go through that process, or do you do them in tandem? Explain that, because I just want to make sure we're clear about registering your business and registering the name of your business.
Absolutely, and thank you for asking that, because that's another misconception out there. So registering with the state, you're registering a legal entity, that's a company. Registering your trademark, that's with the USPTO, which is a different government agency that regulates the use of trademarks, right? It is not the same thing. So just because your name is eligible to register in your home state where you're operating from, it does not mean that you can use it as a trademark if someone else in another state is using it. Because the database of which they're looking to see whether or not your name is eligible for registration at the state level, it's not for trademark purposes. In fact, even registering your business name and then registering a trademark at the state level, it's two different analyses that you have to do. So just because you registered it as a company doesn't mean it's going to also be eligible for registration as a trademark. So it's two different things. It's not one and the same. The idea is that you want to hire an attorney at the moment that you decide that this is the trademark that I'm going to use, whether it's your name, tagline, if you have a nickname that you want to utilize, or if you have different products or different service offerings that you want to brand as something different, you can own all of those trademarks under your company. So it doesn't necessarily just have to be like one name, right? It can be multiple. For example, Coca-Cola, you know, they have other brands underneath them, such as like Fanta, right? So Coca-Cola is its own drink and its own, that's the company name, and that was their original product, but then they also expanded into other products that they branded as something different, but they're all owned under Coca-Cola Inc., right?
Okay, Alicia wants to know, I hope I'm pronouncing your name correctly, to clarify, once I start the trademark application process, I can use TM. And once registered, I use the R symbol, correct?
Correct. You use the TM the moment you use it. So whether you started the application or not, okay, that's your common law right to that trademark. So you start, as soon as you have your, as soon as you launch, start using the TMs. If you don't hire an attorney to do a clearance search for you, you're open to liability for competing with an existing brand. So there could be a likelihood of confusion with a similar mark that could cause you to be a defendant in an infringement suit. So a Google search is not sufficient. The search
I'm so glad you said that.
Because, so think of it this way. If you did a Google search and let's say your Dove chocolate and Dove soap is already out there, you would have probably done a knockout and said, okay, I can't use this name, when in fact you can, right? Because of the different trade channels. So it can work in that way, or it can work in the alternative where you're like, well, they're in a different state or it doesn't look like mine. As I've stated, determining the likelihood of confusion is a legal analysis that lawyers can fight over in court for like 2 or 3 years. So it's not something that's as simple as, it's not the same. Like I write a legal memo on it. I, explain to my client, this is, the impression, but it's also just based on my legal opinion, and reasonable minds can differ. So you just want to understand the risk, because no one can really give you with certainty unless it's an arbitrary name that no one has ever used before. It doesn't exist. You've made up a name, you put some names together, and it's something that doesn't mean anything, doesn't exist anywhere. No one can really give you with any certainty whether or not it can cause a likelihood of confusion or not.
Lenora wants to know, does service standard count as Goodwill asset?
Yeah, absolutely, 100%. Anything that's going to make the consumer pick your company over your competitor. Why should they come to you? Like, what is the reason behind that, right? I like to go to Chick-fil-A because I love the way I feel when I go through the drive-through or I have an interaction with any of their employees. It makes me feel good.
Thanks a lot, Selma. Now I'm hungry. Go ahead.
Sorry. But that's how I think of like Goodwill, is how is the feeling that your consumer has with you that makes them choose you over your competitor. There's a lot of other, food chains that sell chicken sandwiches, but they may not have the same quality of chicken, right? They may not necessarily have the same type of service. So it's like, what does the consumer think about when they're looking for a particular service provider or a particular product? So for service providers, a lot of times part of your Goodwill is your reviews. right? So you want to be mindful of that. If you have really bad reviews, the likelihood that someone is going to choose you over a competitor is pretty slim, right? But if you have great reviews, that can add to the value of your trademark based on the goodwill that you've cultivated.
And as small business owners, we want to do good business, right? You brought up Amazon before. I will break my neck to get something off of Amazon from even before I go to the original website, because I know it's going to get delivered on time. I know I can track it. And I know if there's any problem, they're going to give me my money back. So that goodwill has made me invest in that company, as opposed to a startup that I'm like, I'm not sure what their shipping might be. So, and it's unfortunate for small business owners because these big giants come in and they're so good at it, but it's a great example of how we as small business owners need to monitor our service, why we got into this business in the first place, and how and why we want to give good service to our customers and clients.
Yeah, absolutely. And then there's some people, you know, I represent some Amazon sellers, and so I see how the small business owners that are affected by Amazon's practices and how they're really trying to dominate in each and every market. And there's been research as of late where essentially they're looking at products that are selling a lot. And what they do is they label it Amazon's choice. And then it knocks off that smaller business that basically generated the goodwill of this particular product to begin with, right? So Amazon, I don't know, I feel a little, I love it as a consumer, but looking at it on the back end of how some of my clients are affected, that goes to their goodwill from my perspective, right? So I wouldn't buy stock, you know, in their company because I just don't believe in their practices, but I'll buy from them products because of what you said. You know, that Amazon Prime, and you're able to get something right away. So that shipping stamp, for me, I see why.
Yeah. So two people are asking, how much does it usually cost to get a company trademark? And is there a range on on the cost to hire a trademark attorney? And also they want to know where to find a trademark attorney. So where do they find them? What's the range on the cost? And how much does it cost to get a company trademark? So everyone is concerned about budget. Selma,
no, I understand it. Listen, I'm a business owner myself. So it really depends on the type of service that attorney is going to provide you with, and whether or not you're getting a comprehensive search or if you're just getting a search at the USPTO level. So it can range based on that type of service and their relationship with you. So it can be anywhere from $2,500 to $3,500 is pretty much a good range to budget for. Anything less than that, I would look to see what exactly are they providing you, and are you actually getting services that are protecting your brand. So some attorneys may not explain to you specifically whether or not that's sufficient of a search. Let's say, for example, you only do a search at the USPTO level. That doesn't protect you from common law rights that I referenced earlier about someone using it in Utah without registering it, right? Because first in use is first in right. So obviously the comprehensive search is going to require a lot more of our time because we're going state by state, figuring out what other companies are registered as this name, right? And then is there anyone else using it in different jurisdictions, and then making sure that you're fully aware of all of the legal hurdles that you might face through the trademark application process, along with after you have it registered, the likelihood of there being a cancellation. So I would definitely ask what are the scope of their services, and be able to identify whether or not they're providing comprehensive searches or common law searches is another way to say that, or if it's just at the USPTO level. And then being able to see what is their communication with you. Are they high volume type of practice? Do they understand your business? And being able to make a decision from there. And then also understanding that there's different attorneys are going to charge different things just based off of their goodwill, right? That's another thing that, you know, our fees are priced on our goodwill as well.
Right. So someone asked, would a nonprofit need a trademark?
Every company needs a trade. Any company that has a brand needs a trademark. So, and even a person. So I've branded myself as a millennial business lawyer because that's the name that I utilize for my speaking engagements. And that's the name that I utilize for my legal services that I provide. That's unique to me. So I registered it under me. I own it, not my firm. And the reason being is if I were to ever sell my firm, I could never sell my trademark with it. I wouldn't want to, because that's unique to me. But then my firm will have the logo, the name, slogan, and all of that registered under the firm.
And then Karen wants to know, is it possible to update trade channels after a trademark has been issued? And to do this, would you file a new application or add an amendment to the existing issued trademark?
File new applications, which is why it's important to make sure you do it right the first time and you're able to file. So there's two types of applications you can file: an in-use application, right, based on the fact that you've already used it in commerce, and then an intent to use application based on the fact that you're intending to use it in commerce at a later time, just not right now, but you want to secure that priority date, right? So that's why when I say you want to let your attorney know your future plans, because once I know that, I'm going to file two separate applications, even though it's within the same trade, might be different trade channels. I want to make sure that I secure that right for my client. So, and then if you don't include everything in your original application for the things that you're already using it for, then you have to file another trademark application within the same trade channel and you're wasting money. So you want to make sure you do it right the first time. Or worse, you may not even have it protected. I had a client come to me and they were like, oh, I already have my trademarks registered. I pull it up and I'm like, this is not even the service you provide. Are you sure this is, where did you get it done? And it was one of those online platforms that was like $2.99 or something like that.
Anne wants to know, do you recommend that a small business owner trademark their name and logo prior to registering as a business?
No, you want your company to own everything. You should, before you start operating any kind of business, you need to have your business entity up and running, because you need to be able to have a separate business account. Everything needs to be separate from you. States vary on, holding business owners accountable or liable for personal liability, meaning that you're responsible for any of the debts or any of the issues that arise from your business dealings if you don't have that corporate shield of that business entity. The other thing I want to mention is a DBA is not a business entity. It does not have that corporate shield that protects you from personal liability. It's just saying I am a sole proprietor or a general partnership if it's one or more people that are doing business together, and we want to call ourselves this so that if anyone has an issue with our business, they know where to come and sue us.
Karen wants to, she said, I'd like to pursue an international trademark for use within Europe, Asia, Australia, New Zealand. What resources can you share for finding an international trademark attorney? And as a business owner, for me to personally learn about this process.
So typically your trademark attorneys in the US have relationships with other attorneys in other countries. So I know that in the US, we're able to register through the Madrid Protocol. US attorneys can do that. If we're going into different countries that didn't opt into the Madrid Protocol, then at that point we'll outsource to an attorney within that country. And so you just want to ask the attorney if they have a contact, and if not, they'll find one for you. So it's much easier that you utilize an attorney to talk to another attorney so that you're not caught in the crossfire, because they may recognize that you're not necessarily able to go after them in their country of origin because it's going to require you so much more money. And then you want to make sure it's done right. So you want to have the oversight of that US attorney, making sure that it's done properly.
Now, we've done a whole website on this, but I'm going to ask you to do this briefly for Shayla. She wants to know, what's the difference between a trademark and a copyright?
So trademarks protect the brand, right? The brand identity and the source of origin that distinguishes the services or products that you're selling in commerce from one company to the other. That's trademarks, right? So think of names, slogan, colors, sounds, even smells. There's a flip-flop company that smells like coconuts. So apparently if you walk through the store and you smell coconuts, that means that company is, they sell their flip-flops there. So that I thought that was unique. But really anything that identifies your company in commerce that the consumer is able to say, oh yeah, that's, I'll give you an example. When I say you're in good hands, what do you think of?
State Farm.
Allstate.
Allstate. Oh, geez.
Yeah. It's okay.
One of those states.
Right. So think of it from that perspective. I didn't have to say Allstate, but I said, oh, you're in good hands. And automatically the consumer is going to be able to identify that company. So that slogan, trademark, identifies the source of origin of that particular service, which is Allstate, right? Copyrights, they protect original works of authorship that consists of 6 types that you're able to register. So they essentially protect primarily tangible things. So think of it as music, books, any kind of literature, really, software code, photographs, graphics, you know, really anything that's considered an original work of authorship within those 6 confines of copyright laws.
I think you just answered Lenora's question, who was, she's considering writing a life story book that includes original quotes created by her with portions. Do I need to consider trademarking, i.e. name of book, storyline, etc.?
Trademark the book name if it's going to be part of the series, but you definitely want to copyright the book and the quotes and everything within.
And then George wants to know, he says he's a public health consultant with G3 Associates, and that's his name. So do I really need to trademark my name? So he's using his initial, and then it looks like he's the 3rd, so he's George Kerr the 3rd, and so it's G3 Associates. Does he really need to trademark his name?
Yeah, because anyone else can use G3 that doesn't even have that, that's not within the same name, right?
And so if you just use your name, do you have to trademark it? I guess you do, because there could be somebody else out there in the universe that has the same name. Okay, so you talked about you can use your trademark to secure financing. Can you tell us a little bit more about that? In these troubling times, that's what perked up my ear.
Oh, so if you have a registered trademark and it's valuable, you have to hire people to do evaluations on them, then you can use it as collateral. It's an asset of your business. Same thing as like if you had a truck or a car or a computer or any other type of collateral that you would utilize for financing. Trademarks are part of that same collateral. It's just an intangible asset, but it's still an asset nonetheless. And it's part of your asset and liabilities list. So once you do have that trademark registered, you have it as an asset of the company, and it has a $ next to it based on the Goodwill. Will tell you the value of it.
I think we touched on this, but we'll revisit it because we still have a little bit of time left. When an existing company changes its logo or slogan, this is from Karen, are they registering a new trademark for every change? For example, Coca-Cola in the 80s has a different logo, slogan, and colors than Coca-Cola in 2020.
Absolutely.
So they are changing every time.
Yep. And you have to register it every time. Starbucks is one of those that it took them a long time to develop their logo. So they went through like a few variations, but they've even went so far as to register like variations of how people have like tried to compete with them, so that they know that no one else is able to utilize it. But they've come, like, you'll see their progression in their trademark filings, where how long it took them to get to the logo that they're at now. But yeah, anytime that you change it, you absolutely need to file a new trademark, because the other one is no longer being in use and it can be considered abandoned. So if I'm a competitor that sees that I want to use that particular trademark, my argument to you to cancel your trademark is by saying, well, you're not even using it anymore. You're using something completely different or a variation of it. Therefore, you abandon the use of the other one, which is a legal right to cancel a trademark.
When do your spidey senses start to go up that someone's infringing on your trademark?
Anytime a customer calls you and says, hey, is this you? Or you see it in commerce, you see it out there. Social media handles makes it super easy now, right? Because you're able to see. We really can't exist as a business if we don't have social media presence for the most part, unless we're one of those old mom and pop shops in one of those small towns where that's not necessarily the norm. But for the most part, everyone is operating online and everyone has a website. So the moment that you see that people are starting to use it, you need to police it. So after the trademark is registered, your work doesn't stop there. So you do get 10 years protection, but you do have to maintain it within that 5-year mark to renew it. And you can continue to renew indefinitely. So trademarks can last forever as long as you use them. But you also want to make sure that, you're policing it out there, because if you dilute it by allowing everyone to use it, then it's not strong anymore because everybody can use it. And that would be an argument that someone else can use to say, well, you don't even use it anymore.
Right. So Lolita wants to know, what are your thoughts on organizations such as Legalzoom in regards to trademarks? And I think someone else asked a very similar question What do you think about them not hiring a specific trademark lawyer and going to something like a Legalzoom for this?
So it's interesting because I want to say a couple of years ago, a law firm out of California sued Legalzoom for unauthorized practice of law because of their trademark filings. Apparently, it was alleged that the people who were registering the trademarks were not attorneys. And so considered unauthorized practice of law, and that's something you want to be mindful of. I can say to you that a lot of the mistakes that I have fixed have come from Legalzoom.
Well, there's that. Elisa wants to know, should nonprofit, oh no, I'm sorry, not that one. Someone wanted to know, oh, Nadine, can you copyright recipes?
Yes, you can. Now, with recipes, you want to be mindful of that. So you might have something that's so proprietary and so different that no one else can figure it out, right? Then you might want to maintain that as a trade secret. An example of that is the Coca-Cola formula, right? Their recipe for their syrup. The KFC chicken batter recipe that they have is considered a trade secret. Once you register it as a copyright, it's basically public information, right? So if it's, you know, something that you have a certain type of cookie or a certain type of pie or a certain type of something. I have a client who has a particular type of pie that's like to die for, but it was so good that it's kind of hard to figure out what all is in there, even if you're a professional chef. So we took the route of trade secret versus copyright because we wanted to make sure that no one else is able to recreate it. Now, if you have a recipe book, that's a little bit different because you don't want someone else to steal the same recipe book and create their own. So then at that point, it's already going to be published because everyone's going to have it because you're selling a book.
We've got a couple of minutes left. I'm going to throw these both at you. So are apps something that need to be copywritten rather than trademark? And should nonprofits trademark their successful program names?
So if the program names are identifying the type of program that you have, then yes, it's considered a trademark, right? Because that's how you're branding it. What was the first question? I'm sorry.
Are apps considered a copyright? And are apps considered, do apps need to be copywritten rather than trademarked? And should nonprofits trademark their successful program names?
Yes. So for apps, you have the software code that could qualify for copyright protection or patents. That wouldn't, the name of the actual app would be the brand. That's what would be trademarked. But the actual software, that'll be determined as to what IP rights you want to protect based on whether you want to go the patent route or the copyright route. And that requires a legal analysis to figure out based on your business plans, based on the code, what actually route you should take, or both.
All right, you guys, we are wrapping up. So I want to thank you all for joining us. Please make sure that you put in the chat in this last minute that we have here, the name of your company. If you have not registered for this Zoom in your company name, we want to make sure that you get credit for it. And we want to make sure that I can get the presentation to you. Coming up next week, we're going to be talking about the GSA schedule, and we'll be talking about getting certified for your 8A. So if you don't have that right now, please make sure that you join us next week. Let's give a round of applause to the Millennial Business Lawyer. Did I say it right? Is that the right copywritten and trademarked name? Trademark name? All right. And thank you guys very much. We'll be emailing the presentation with you. Give us a couple of weeks. The presentation and the video will be up on the website. Thank you so much. Always check in with dcsbdc.org for future webinars and future events that we're holding online virtually because we cannot get together in person yet. So thank you guys for joining us. I really appreciate it. Thank you, Selma. Appreciate it. Bye, guys.